friends, welcome to The Point. In this session, let's discuss about the amendment of the Constitution of India. So, similar to other written constitutions in the world, Constitution of India, it also provides for the amendments in order to adjust itself into the changing conditions and according to the changing generations and the needs required. And there are certain procedures that should be followed while amending our constitution. Amendment of our constitution, it is not as easy as Britain constitution or it is neither difficult as USA constitution. So we can say that Indian constitution is neither flexible nor a rigid, but it is a combination of both flexible and rigid. Article 368 in part 20 of the Constitution, it deals with the powers of Parliament to amend the Constitution and its procedures. Article 368 states that the Parliament may exercise its constituent power or amend the way of addition, variation, or repeal any provisions of the Constitution in accordance with the procedure that is laid down for the purpose of amendments. The Parliament cannot amend certain provisions which comes under the basic structure of the Constitution. So we will be discussing about the basic structure of the Constitution in our next session. Procedure for amendment. So what are the procedures that is followed for amending a constitution? So to amend a constitution, it should be initiated or it should be introduced as a bill either in Lok Sabha or Rajya Sabha. Amendment of a constitution, it should not be introduced in state legislature. Constitutional amendment bill, it can also be introduced by a minister or by a private member, and it does not require a prior permission of the president. This bill, it should be passed in every house by a special majority. What do you mean by special majority? Special majority means a majority of people, that is more than 50% of the total membership of the house, and a majority of 2/3 of the members of the house present and voting. Every house must pass the bill separately. In case if there is any disagreement between the houses, a joint sitting is not made for constitutional amendment bill. And suppose if the bill seeks to amend the federal provisions of the constitution, and such a bill, it should be ratified by the legislatures of half of the states, that too with a simple majority. What is a simple majority? If there are 100 members in the house present and then 50 plus 1, that is half of the vote plus 1 extra, becomes a simple majority. Once the bill is passed either by a simple majority or a special majority, then it has to be presented to the president for his assent, and the president must give his assent to the bill. After the president's assent, this bill becomes an act. Types of amendments. Article 368, it provides for two types of amendments, that is by special majority of Parliament and also through the ratification of half of the states by a simple majority. But there are also some other articles that provide for the amendment of certain provisions of the Constitution by a simple majority of the Parliament. That is, the majority of the members of each house present and voting. The Constitution can be amended in three ways. They are amendment by simple majority of the Parliament. There are a number of provisions in the Constitution that can be amended by a simple majority of the two houses of the Parliament outside the scope of Article 368. And these provisions include establishment of new states, formation of new states and to alter the areas or boundaries of the existing states, abolition or creation of legislative councils in the states, quorum in the Parliament, salaries and allowances of the members of the Parliament, rules of procedure in the Parliament, privileges of the Parliament, use of English language in the Parliament, use of official language, citizenship acquisition and termination, union territories, and so on. All this can be amended in the Parliament by a simple majority. Amendment by special majority of the Parliament. The majority of the provision in the Constitution, it needs to be amended by a special majority of the Parliament, and that is a majority that is more than 50% of the total membership of each house and a majority of the 2/3 of the person of each house present and voting. The word or the expression total membership means the total number of members which comprises the house irrespective of the fact whether they are absentees or is there any vacancies. The provisions which are amended by a special majority includes fundamental rights, directive principles of state policy, and all the other provisions which are not covered by first and third categories. Amendment by a special majority of the Parliament and the ratification of half of the state legislatures. So this provision of the Constitution is related to the federal structure of the polity, and it is amended by a special majority and also with a consent of half of the state legislatures, and the consent of the state legislature is taken by a simple majority. If suppose any one or two states, it does not give its opinion or it does not take any action on the bill, it does not matter because the other half of the states gives their consent, and thus the formality gets completed. And also remember, there is no time limit within which the states should give their consent to the bill. Provisions that can be amended by this way is election of president and its manner, and the extent of executive of the union and the states, Supreme Courts and the High Courts, distribution of legislative powers between the union and the states, any of the list in the 7th schedule, representation of the states in the Parliament, and the power of Parliament to amend the Constitution and its procedures under Article 368. Criticism of the amendment procedure. Critics have criticized the amendment procedure of the Constitution on some of the grounds, like there is no provision for a special body like Constitutional Convention in USA or a Constitutional Assembly for amending the Constitution. It says that USA does not have any Constitutional Assembly to amend the Constitution. The constituent power, it is vested in the Parliament and only in few cases in state legislatures. This is also a criticism for amendment. The power to initiate an amendment to the Constitution, it lies within the Parliament. Like USA, the state legislature cannot initiate any bill or proposal for amending a constitution in India. Major part of the Constitution can be amended by the Parliament alone, either by special majority or by a simple majority. Only in few cases, the consent of the state legislature is required, and that too, only half of them, while in USA, 3/4 of the state should give their consent. The Constitution, it does not prescribe the time frame within which the state legislature should ratify or reject an amendment that is submitted to them. It is silent on the issue whether the states can withdraw their approval. There is no provision for holding a joint sitting of both the houses, that is Lok Sabha and Rajya Sabha, if there is a deadlock over the passage of the constitutional amendment bill. A provision for joint sitting is made in the case only on ordinary bills and not for any other bills. The process of amendment is similar to that of legislative process, except for special majority. The constitutional amendment bills is to be passed by the Parliament in the same way the ordinary bill is passed. The provision relating to the amendment of the procedure, it is too sketchy, and hence they leave a wide scope for taking the matters to the judiciary. See you in the next session with some other interesting topic. Thank you.